several weeks, I have gotten a lot of questions about Florida Bill 1718. It was signed into law by Governor DeSantis on May 10th of this year. So what does it do? Quite a lot of things, actually, and most of them go into effect on July 1st of this year. So let's break them down for you. First, the law imposes a limitation on identification documents, such as driver's licenses. So several states will issue driver's licenses or other ID documents to classes of persons with unlawful presence in the United States or that haven't proved lawful presence in the United States. So what this law does is it says that we don't recognize those ID documents in Florida. So for example, if you are from out of state, but you're driving in Florida with one of these driver's licenses and you're stopped by police, the police do not recognize that license. So even though you have one, you will be cited for driving without a driver's license. What it also does is it restricts funding to organizations or entities that issue identification documents to classes of persons with unlawful presence. The interesting thing is the law does not define what unlawful presence means. So whether it is someone that is in the United States without a visa, but perhaps is waiting to apply for asylum, or some other type of class, I'm not quite sure, and so that's something we'll have to see how it is interpreted in the courts as it's implemented. Second, the law requires data collection in hospitals. Not all hospitals, but if it's one that accepts Medicaid, then it should be collecting this data. The data includes whether a patient is a U.S. citizen, whether they have lawful presence, or whether they have no lawful presence in the United States. Now, it does exclude identifying information, but in the report that goes every year to the legislature and the governor, it should also include things like the number of emergency room visits, the number of hospital admissions, the cost of uncompensated care for unlawfully present individuals, and that impact on the hospital's ability to care for the public. That information will go every year to the governor and the legislature for them to interpret and use moving forward. Third, the law sets forth penalties for the employment of unauthorized immigrant workers in the United States. Now, unlike the other provisions, this one does not go into effect until July 1st of next year, 2024. But what it does is it creates penalties for employers that knowingly hire, employ, recruit, or refer unauthorized immigrant workers. For a first violation, they can be placed on probation, and for a second violation, their license to conduct a business in Florida may be suspended or even revoked. Now, if a worker, an unauthorized immigrant worker, is using a fraudulent ID to work, then they may be charged with a third-degree felony, which is punishable with up to 5 years imprisonment. Fourth, private employers with 25 or more employees must start to use the E-Verify system to verify an employee's eligibility to work. Now, this goes into effect July 1st of this year. However, the penalties do not attach until July 1st of next year, 2024. Once the penalties do attach, if an employer is found to be non-compliant, then they will have 30 days during which to get into compliance with the E-Verify requirements. If within any 24-month period they're found to be non-compliant 3 times or more, then they will be fined $1,000 per day until they get back into compliance with the E-Verify system. Now, it's worth noting that critics of the E-Verify system state that it is frequently found to be inaccurate and that it creates delays for employers and employees. Fifth, the law expands the definition of human smuggling. Now, this is a big one, so let's read exactly what it says. The provision reads, "A person who knowingly and willfully transports into this state an individual whom the person knows or reasonably should know has entered the United States in violation of law and has not been inspected by the federal government since his or her unlawful entry from another country commits a felony of the 3rd degree." If it's a minor that is being transported, then it actually rises to a felony in the 2nd degree. So one concern that a lot of people have is that there's a lot of mixed status families in the United States, meaning that some people in a family may be documented while others are undocumented, and those persons frequently travel together. So let's look at how that may or may not impact you. So first, the law says that it's looking at transportation into the state, not within the state, meaning that if you already reside in Florida and you're going from one city to another city, then this law should not apply to you. However, if you are coming from another state into Florida, then it likely will apply to you. Next, let's look at this provision referencing the transport of persons both that entered the U.S. in violation of law and has not been inspected by the federal government since the unlawful entry. So, for example, if you're transporting a friend that entered the United States illegally, however, maybe they were apprehended by Border Patrol and now they're in removal proceedings, then that person should not be someone that you're transporting in violation of this provision. Also, let's look again at that section because it says that the person must have entered the U.S. in violation of the law. So if a person overstayed a visa, if they entered the United States with a valid tourist visa or a valid student visa, for example, and then they overstayed that visa, then this law also should not apply. Sixth, the law expands Florida's DNA database collection program. Now, what this program does is it collects DNA from individuals that are charged with committing a felony or that are convicted of committing a felony or other misdemeanor offenses. So what this does is it expands the program to apply to persons that are in local custody on an immigration hold. So what that means is that the person is being held locally while immigration agencies determine whether or not they are interested in collecting that individual into their own custody. So this law mandates that the local agency immediately collect DNA samples of that individual while under that ICE hold, regardless of whether or not immigration actually ends up collecting that individual or if they're simply released. The last provision of the law that we will be looking at is the additional $12 million that is going into the unauthorized alien transport program. Now, what this money does is it will relocate migrants that are inspected unauthorized aliens. In other words, persons that were at the border and inspected by immigration and released into the United States, but were not actually admitted as lawful immigrants or non-immigrants. Now, you may have heard about this in the past with the infamous Martha's Vineyard case, where Governor DeSantis paid to fly recent migrant arrivals from Texas to Martha's Vineyard and then just kind of dumped them out there. Now, this is that same program that will be used by Governor DeSantis moving forward. And there you have it, Florida Senate Bill 1718 in a nutshell. Thanks for joining and thanks for listening.